So we're here on the case of, I hope I'm pronouncing these names correctly, Akins versus Patadar Investments. This oral argument is being live streamed so that the public can view it. You each will have 20 minutes aside for your argument. Unless I hear otherwise, I'll assume the appellant wishes to reserve 5 minutes for a rebuttal. I do wish to introduce the other members of the panel. I have Judge Eric Eisnagel and Judge Meredith Sasso. So with that, is the appellant ready to proceed?
Yes, Your Honor.
Okay.
And I will
do so.
And I will reserve 5 minutes.
Okay.
May it please the court. I'm Tyrone King, and I represent the estate of Larry Akins. This case arises out of the shooting death of Mr. Akins at a strip mall here in Orange County, Florida, in Orlando. The killer is named by the name of Corey Jackson. Mr. Akins was on the property right outside of the parking lot. He was killed on the property. His possessions and his belongings were outside the parking lot and outside the area of the parking lot and the property. Mr. Akins was a roofer, a father of 3. He was a DJ and a music lover. He was talking to a friend, a man by the name of Anthony Clark, when Mr. Jackson pulled up and parked his car in the appellee's parking lot. Mr. Jackson exited his vehicle, fired a shot at Mr. Akins, hitting him in the back, fired another shot at Mr. Akins, hitting him in the head. Mr. Clark, Mr. Akins' friend, tried to get away, and Mr. Jackson stated, "Do you want some?" Chased Mr. Clark down and shot Mr. Clark in the face. Mr. Clark survived. Mr. Akins did not. We filed this wrongful death suit alleging—
Counsel,
Yes.
did you need, how important is the affidavit of Yannicka McGee to your case? I mean, if you didn't have that affidavit, could you still prevail?
We could. Our position is that this was a strip mall, much like any other mall in Florida. It is open to the public. And based on the Wood versus Camp case, Wood versus Camp expanded the scope of invitees beyond Post v. Looney. The trial court relied on Post v. Looney and the appellee's argument that if Mr. Akins had not been expressly invited, there could not be an implied invitation. In Wood v. Camp, the Supreme Court expanded—
Counsel, did the appellee's summary judgment evidence, did they meet their burden with their evidence under the statute 768-075?
They did not, Your Honor.
Why not?
2 reasons. We filed a summary judgment motion in an attempt to prevent the appellees from using the U.S. Code as a basis for a felony. As the court is aware—
No, I'm still talking about 768-075.
Correct. 768-075, I'm assuming you're referring to paragraph 4, the felony portion, where they had immunity?
Is that the undiscovered trespasser statute, or am I reading my notes wrong here?
There are 2 portions of 768.075. One portion relates to the undiscovered trespasser. Mm-hmm. And that portion deals with whether or not the individual, the person who is subject to the status evaluation, had a reasonable belief that they were authorized to be where they were. Mr. Akins, according to all the evidence in this case, was on the property frequently, meaning he was there so much that even law enforcement and members of the community referred to him as the CD man. He was always there. No one ever trespassed him, according to Mr. Patel, the designee for the appellee. No one ever asked him to leave the property, and this had been occurring for years. According to Ms. McGee, it had even been going on while she was a tenant at the property. So with 768.075, you have to look at what the individual, in this case, Mr. Akins, reasonably believed. Did he reasonably believe that he was authorized to be there? And I believe all the facts and circumstances in the case indicate that he did.
I think to follow up on Judge Eisnogel's question, though, is that information evident without the affidavit?
It is.
Okay, and how so?
It's based on the evidence that the appellee utilized. The appellee was pointing out that Mr. Akins was there all the time, that he was on the property with his van. Everyone knew him. He was there every weekend. He was referred to as the CD man because he had been there so frequently. I mean, it's just the file, the record is filled with evidence of the fact that Mr. Akins had been known to be at this property for so long that it was impossible that anyone did not know him and did not authorize him to be there.
And I guess what specifically that they relied on for summary judgment?
They relied on the
summary judgment motion.
With regard to the status issue, what they relied on was the fact that there was no express authorization for Mr. Akins to be on the property. And when you think of a strip mall, no one in the state of Florida receives an express invitation to visit a strip mall. To go on.
He wasn't, I mean, counsel, he wasn't visiting, he was selling things, right?
Well, his van, according to the court's trial order, the summary judgment order, his van and all of the equipment and CDs was outside the parking lot. It wasn't in the parking lot.
So let me ask you this. Is it relevant for the court to consider for whose purpose that the decedent was on the property? That is primarily for his purpose or primarily for the property owner's purpose?
No, Your Honor. The Supreme Court eliminated the mutual benefit or benefit purpose in this analysis. It went straight to the invitation test and eliminated the benefit analysis. So, and I think that was done either in Looney or Wood versus Camp. So that type of analysis, it went away.
Well, let me ask you this. For instance, the person who killed the decedent, would he be viewed as an invitee because the mall is open to all people, or would he be viewed as not being invited since his purpose was to commit acts of violence against others?
Well, there is no indication that this individual went to the property to do anything other than to kill Mr. Akins.
Right, but you know, you were saying it's kind of open to anyone, and that you don't consider the purpose of the person on the property. I mean, so in the case of the murder, would we consider that him an invitee because we don't consider the purpose he's there, or do we consider him to be an uninvited licensee or trespasser since his purpose was to commit acts of violence against others? And of course, that leads to the next question of, if we do view the murderer as uninvited licensee or trespasser, why wouldn't we consider the purpose for which Mr. Akins was on the property? Well,
the issue is when it comes to Mr. Akins, all of his items were outside the property. When he was killed on the property, when he was moving and his body was physically on the property, because he was killed and can't speak, we have no idea why his physical presence was on the property. And I anticipated the court's question, and I analogize it to this. If Mr. Akins intended to go to the convenience store to buy a bottle of water and he was killed, the fact that he can no longer speak means that any person that entered a property that was open to the public, a convenience store, Publix, any shopping plaza, any person that did that, if they didn't make it into the store and they didn't make the purchase and have a receipt, that person would be considered a trespasser.
But in this case, there was evidence that Mr. Akins came on the property on a regular basis for the purpose of selling CDs. Would you agree with that?
And see, I believe that this is the same analysis that the trial court was making. Mr. Akins's vehicle on the date of this incident was not on the property. The appellee has not established that Mr. Akins was on the property selling these CDs. What they pointed to was the police reports and such indicating that he was at
Counsel,
this.
all of his equipment was there. The CDs were there. Your position is that because the truck itself or the van was parked a foot off of the property, that he wasn't on the property and therefore could not have been trespassing, could not have been selling CDs on the property?
Correct. If his vehicle is off the property, how can he, for purposes of 768.075, for purposes of the statute, how could his vehicle and his materials be used to say this is what he was doing on the property?
Well, cut against your argument, though, if you're relying, for example, that there's an issue of summary judgment because he had done this in the past, and therefore the store owners must know, wouldn't that same logic apply to whether he was trespassing? He's done this in the past multiple times, and so it's reasonable to infer that he was doing the same thing this time, selling CDs on the property.
Well, if that inference is made in a summary judgment proceeding, the inference has to be applied in favor of Mr. Akins. Mr. Akins wasn't the moving party. So if there's going to be, if the equal inference could be that Mr. Akins, his vehicle was off the property every time that he was there, as opposed to being on the property. In this instance, his vehicle wasn't physically on the property. And so if the court is going to draw that inference in favor of anyone at the summary judgment point, it must be drawn in favor of Mr. Akins, meaning to move the case along as opposed to eliminating his ability to proceed.
So it's your theory that he was actually selling the CDs, despite the evidence that he routinely sold them on this property, that he was might have been actually selling the CDs on the adjacent property, just feet away from this property.
Correct. On this date, on the date of, we can't utilize the fact that.
Well, let me ask you this, counsel. If he was selling CDs on another property, why would this appellee have any duty to him at all?
Because the killer was at the property. The killer utilized the property.
So hold on. So you're saying that the owner of a property not only has a duty to the people on the property, but has a duty to people who aren't on the property as well?
It has a duty to the people within the foreseeable zone of risk. The foreseeable zone of risk was raised in our complaint.
Do you have any case from any jurisdiction that says a property owner not only has a duty to warn individuals on their own property, but also everyone on surrounding properties? And if so, how far away do they have to go?
Well, I believe the foreseeable zone of risk case law that we've seen from the Supreme Court addresses that issue.
Tell me the answer, counsel. How many properties over? I mean, do they have to go 100 feet, 500 feet? How far do they have to go as far as warning people in this situation?
Well, I don't believe our sole issue is warning, but they have to act reasonably enough where, for instance, in this case, a bullet would not travel and hit someone. This property had
a bullet can travel pretty far, right? So you're saying the distance would be the distance that a bullet could travel?
For this instance, yes. For example, this property had, and according to the complaint, had over 1,100 calls to the police in a 3-year period. If someone was on this property, was involved in criminal activity and fired a shot, and that bullet traveled a block and went through someone's window and hit someone, that property owner could be liable for that within that foreseeable zone of risk. It would not be the landowner's responsibility to protect someone in his home from a bullet traveling from the shopping plaza. The only cases that I can
Which
think
case
of,
supports that? Your position?
the only cases that I can think of are there are these foreseeable zone of risk cases related to security where an individual landowner or business operator knows that someone is utilizing their an adjacent parking lot. They use this parking lot and their customers park over there and come back. They would owe a duty if that parking lot had foreseeable crime. They would owe a duty to their customers who were going over to this parking lot. So I can't cite the case, but those are the cases that I recall from this type of practice.
Okay, you're at 5 minutes. Do you wish to reserve the remainder of your time for rebuttal?
Yes, Your Honor. I believe the remaining time is going to be necessary.
All right, thank you. All right, for the appellee.
May it please the court. Good morning. Mark Tinker on behalf of Patadar Investments. I'd like to address, I think, what have been the two main focuses of the court's questioning, and I'll start with the easy one. I think, Judge Eisnagel, you asked if Patadar had carried its burden on summary judgment, and there is testimony from Ankur Patel, who is the vice president of Patadar. He testified that he's the one that's responsible for day-to-day operations of the company. At pages 524 through 525 of the record, he testified that there was no authority for him to be on this property, that he was not authorized to be there, was not authorized to sell CDs and DVDs there. So that was the affirmative evidence.
Counsel, your evidence, didn't your evidence also establish that this happened routinely?
There was evidence that it happened before, yes. And
well, your evidence, I think, indicated as much, correct?
Correct.
So, I mean, appellant's argument is, look, I mean, if it happens routinely, then how is that not sort of an implied invitation?
Well, there's two things to that. And the first is kind of goes a little bit to what the other questioning was what happened routinely was that he had, and this is right in Yannicka McGee's affidavit. That was the second point I was going to get to. She said he was authorized to set up off the property and do this, is what she claimed was, the agreement was, that in order to avoid any cleanup that he could be off the property.
Is there anything in the summary judgment evidence that was relied upon to enter summary judgment that would indicate that it was just an off the property?
Well, that is, I'm citing to their summary judgment evidence, the Yannicka McGee affidavit.
Counsel, I can't find anywhere in the record where they actually identified that as summary judgment evidence.
They did not. You're right.
According to one point,
not identified.
We didn't get into this yet, but 1.510C, I mean, you can't just put something in the record. You have to specifically identify it as summary judgment evidence.
Correct. And that was not done with this. This affidavit was filed years before the summary judgment hearing. It was just kind of buried in the court file, and then it was raised for the first time at the hearing. That was discussed at the hearing, that this is new. We hadn't talked about this thing before.
Can you confirm? I can't find anywhere where they identified it as summary judgment evidence pursuant to 1.510. Can you confirm, did they or did they not ever identify it?
I can confirm they did not. And I can also confirm that it wouldn't have mattered if they had. The affidavit itself, if you look at it, it is inadmissible. Everything that's said in there, it is all hearsay and sometimes double hearsay. It is Ms. McGee saying there was an agreement between two people. She doesn't say how she knows that. She just—
Focusing back on whether the initial burden establishing the absence of material fact was established. Just looking at the summary judgment, it says he routinely sold CDs and vans, parked in defendant's parking lot, routinely was known as the CD man, did not sell CDs or DVDs in any other location besides the defendant's parking lot, sold CDs and DVDs that he copied on his own. Inside his van, no others were selling CDs or DVDs. So if we look at those undisputed facts alone, how would that not create a material issue of fact as to implied consent?
What that would potentially do, and the best that could establish, is that would make him a licensee or a discovered trespasser on the property. There, at no point would it become an invitee on the property, because there was no establishment that he was there, agreed to be on the property for that purpose. Again, the evidence is that the best they could establish, except for the fact that it's hearsay, is that he was allowed to be off the property, right adjacent to the property, selling these CDs. At best, he was tolerated, and under the law, that makes him at
But
most a
counsel,
licensee or somebody who's
for a
tolerated.
discovered trespasser, the statute says you would have a duty to warn of dangerous conditions.
Warn of dangerous conditions not obvious to the plaintiff himself. Avoid gross negligence is the first one, and a duty to warn of conditions that he's not aware of. And again, their evidence in order to make him a licensee, being there a discovered trespasser, is that he's always there and he knows this property. He's there every night doing this.
Let me ask you, if he, every time he was there, he went in and bought a, bottle of water or a soft drink or whatever while he was there, would that change his status?
He would be a business invitee to the extent that he's there buying water, but when he's over set up off the property selling CDs that there's no authority for him to do on the property, then I think you can't, that status of buying a bottle of water doesn't make him a perpetual invitee for the remainder of that 24-hour period or indefinitely, just because he did that until he removes himself some particular distance away. It's his purpose for being there. And I know that was discussed with Mr. King earlier, as far as what about the shooter who comes onto the property isn't purpose relevant, and it absolutely is. When he's going in to buy a bottle of water, he's a customer, he's a business invitee. When he's off the property, bootlegging CDs and DVDs, and with 1 foot on the property, 1 foot off, selling them, whatever he's doing over on the edge, he's fulfilling his own purpose. He's not doing anything that is benefiting the property owner. He's at best a tolerated licensee or discovered trespasser at that point, if he's there often enough.
Are there two duties involved here, the duty to warn and the duty to take reasonable care as far as the maintenance of the premises?
Well, reasonable care would be if he was an invitee.
Right. But two duties in general involved in this case.
Correct.
All right. So following up the questions from Judge Eistogel and Judge Sasso on the duty to warn, if he's a discovered trespasser or an uninvited licensee, what is the duty to warn?
It's a duty to warn of conditions that he would not be aware. And in order to make himself to elevate himself to that status where he's not just an uninvited trespasser, he's an invited or a discovered one, that he's there often enough that he's tolerated to be there, then he has to establish that he himself is familiar with the surroundings. He's there often enough that he attains that status. So there is no duty to warn at that point, because he would have equal knowledge of the premises to anyone else.
Right. So are you saying that a regular customer to a store or mall has the same knowledge about the level of criminal activity or number of incidents as a property owner?
Well, we're not talking about a customer again, because now that would turn him into an invitee if he's becoming a customer. He is someone
but you're saying in his role, either as a discovered trespasser or a licensee, that he would be charged with the same knowledge of the criminal activity on the property. Isn't that what you indicated or were suggesting?
I'm suggesting that if he's off the property, and I think we've gotten away from that a little bit, is he's establishing that he's off the property in order to avoid the issue that would be created if he's bootlegging CDs on the property. He's affirmatively placing himself not on the property, and then claiming that we have a duty to warn him of conditions on our property that could affect him off the property. And I don't believe there's any such duty that could exist. So I think that the question kind of got into a hypothetical that doesn't fit the facts of this case, where he's attempting to affirmatively establish, I'm not on your property, I'm off on the edge somewhere.
Where was he shot? What does the evidence reflect as far as where he was shot?
The evidence, I believe, shows that he was actually, where he fell was on the property. I'm not sure exactly, there was multiple shots. I don't know exactly where each one of them would have been, but I'm not, as far as whether that changes the analysis, I don't believe so. If he is set up off the property, as according to him, selling bootleg CDs and DVDs, and in the middle of a fight breaks out, darts onto the property and is shot there, or darts the opposite direction and is shot there, that shouldn't change the duty as to the adjacent property owners on either side of that property line that he's straddling.
Let me ask you this. Is there summary judgment evidence as far as your client's knowledge of criminal activity on the property?
Well, I know there was summary judgment evidence. So I'll go back to Judge Eisnagel's question that was identified properly. No, I believe that there's references in the record itself, in the
Counsel,
trial file to.
Counsel, if I could stop, summary judgment evidence that was identified as summary judgment evidence, isn't that a requirement of the rules?
Yes, it is.
We can't, I mean, the trial court shouldn't consider, and we shouldn't consider any summary judgment, any evidence that wasn't identified as summary judgment evidence, right?
I completely agree. And
So Judge Evander's question was there any summary judgment evidence?
Then my answer is no.
Well, was that evidence argued, and was there any evidence or any objection to raised on that issue?
In the hearing transcript, I don't recall seeing an objection to whether things had been raised at that point. I know different arguments were made on these topics. I know.
Was it tried by consent if there's no objection that it wasn't identified? Because obviously it was tried, if there's an objection, the party can ask for a continuance or whatever, the judge can rule on it. But if there's no objection, sometimes in summary judgment motions, both attorneys go in and say, Judge, here's the situation. Here's the legal issue. What do you say? Certainly that situation wouldn't require an agreement or requirement that someone put a summary judgment identifier in the record. So I'm asking you, if there was no objection to the reference to your client's knowledge of criminal activity, whether that was a matter that was tried by consent.
I believe I don't know if I'd say tried by consent. And what was argued to the judge is some of it was, and I'm tripping over myself here because I'm looking at this one note that I had made. There was an issue that came up this was the affidavit of Ms. McGee, which was not identified. And that was raised at the hearing to say, Judge, this wasn't identified. This is the first time we've heard about it. This is not proper, but it doesn't matter, Judge, because number one, this is hearsay. None of it would be.
I understand on the
affidavit. So it was argued in that fashion.
I understand on the affidavits. I'm not suggesting the affidavit was admissible. I'm talking about your client's knowledge of the criminal activity on the property. And then my next question was going to be, was there any summary judgment evidence or anything in the record indicating the decedent's knowledge of criminal activity on the property?
Well, I believe the issue was argued the same way, as that the only evidence that was in the court file would be evidence of police calls. And that is not even sufficient to establish knowledge of criminal activity as far as a shooting. You can't just file a note saying there were 1,000 police calls, because that doesn't mean anything. Was that shoplifting? Was that somebody backed into a car in the parking lot and ran off? So there was a call. Was it, saying there are police calls does not satisfy the issue under Florida law. So it was argued that way as far as, whether it was identified or not properly for the hearing.
And that goes back to my original question. What evidence was there about your client's knowledge of criminal activity?
The only evidence is the police calls, where there were a bunch of police calls that were made. And again, that under Florida law, that doesn't establish anything, because it does not mean
there's no evidence. So there's no evidence, for instance, of the number of violent activities on the property.
And not anything to indicate that a shooting could be, imminent or predictable or reasonably foreseeable. No.
Was there even any evidence of criminal acts on the property? Because, like you said, police can be called for non-criminal activities. For instance, a car, bumping into another car, backing out or whatever might result in a police call. Was there any evidence in the record on the number of criminal activity or anything related to calls related to crimes on the property?
To my knowledge, and I'm sure Mr. King will correct me if I'm wrong, but no, nothing specific as far as what these crimes were and whether we could identify them as violent crimes versus the other just police calls that had occurred. No.
Okay.
That specific issue though, was that part of your summary judgment motion on the issue of foreseeability of the crimes?
No,
In
Your
other
Honor.
words, the motion was just focused on duty, right? Or whether the status of the decedent and whether as a result of the status there was a breach of a duty, right?
Correct. But, of course, at this point in the proceedings, anything that is there, anything that is evident in the record, the court could consider. And the one thing that I would like to say is, I know we focused a lot on the statute and, as far as the defense that it creates for trespassers or for people committing crimes on property. The judge looked at this and actually said summary judgment could be granted on both grounds. Even if we get rid of the statute, if we just look at common law status of people on property, and this would go back to, again, we have the normal statuses of invitee, licensee, trespasser. And she looked at this and said, the best that we could get to here again is licensee. At best, he was tolerated. The only things that this affidavit, if you take out the hearsay, the only thing it could establish is that there was some agreement that he could potentially be on the edge of the property, that he had been there before, that he was allowed to be there before, he was tolerated. And I actually need to point out one more thing, because I know they've placed a lot of reliance on this affidavit, the Innica McGee affidavit. Other than having hearsay, it keeps referring to Patidar said, and Patidar stopped by the property. That's not a person. There is no Patidar. The owners of Patidar is a company name. The owners are the Patels. Ankur Patel is the primary person who would be responsible for day-to-day activities there. His mother and father are also involved as president and as another vice president. But the affidavit keeps referring in general terms to Patidar authorizing, without saying who, without saying how the affiant knows this, who she heard it from, where this came from. So it is not admissible evidence for any purpose at this point. But the judge, going back to my original point, the judge looked at all of this and said, with or without the statute, even if we go under the common law, this is at best going to be a licensee. There's no affirmative obligation to protect. All you have to do is avoid what would be gross negligence. Gross negligence is avoiding conduct that is, likely to cause harm, not just foreseeable, but likely. And there's nothing in this record that would establish anything. We just talked about other police calls. There's nothing that would establish that there's likely shooting going to occur on this record.
What do you think? One of the more interesting arguments that the appellant has made is that, look, your own summary judgment evidence said that he was on the property all the time doing this, and that you knew it. Right? Otherwise, you couldn't have done an affidavit saying that he was there all the time. So, what does that do to the issue of implied invitation? Right? They said his argument is essentially, look, he was there all the time and they knew it. All the time. This is the only place he sold CDs. Why isn't that at least an inference of an implied invitation?
And again, that implied invitation is to be off the property, and which kind of doesn't make sense to me to say he had an invitation to not be on our property. We allowed him to not be there. And I'm just reading from the evidence was that in lieu of maintaining the area where he was set up, that he agreed to be outside the property. So the invitation was to not be on our property. So I don't believe that changes anything as far as to say that we knew he was there, we tolerated him to be there, we tolerated him to be not on our property. So that, that just leads back to where is the duty owed to someone who's not there, who's not on our premises?
Why does there need to be an agreement for him not to be on, he can do it, but not on the property?
I would imagine if you're, this is not record material, but I'm imagine if you're a business owner, if he was, want to make sure he's not harassing customers, if he's selling things and not on, right on the edge of your property, I would assume that would what it would be. But again, there's nothing in the record that would indicate one way or another.
Let me ask you this. It's not arguably the most sympathetic plaintiff here as far as someone selling CDs, which may or not have been proper, but let's assume these were Girl Scouts selling cookies, and they put their table right outside the property, but they stood in the property, and your client knew about this, and they were there every Saturday. Would there be any type of duty in that situation?
No, Your Honor, because of the part that you said, setting up this table not just outside our property, setting it up not on our property.
Even if they stood on the property while selling?
I'm sorry, I didn't.
Even if they stood on the property while selling?
That could at most turn them into, we tolerated them crossing over the property line and standing in our parking lot, every now and then while selling. They were at best tolerated, at best a licensee or a discovered trespasser. But the fact of the matter remains that they were setting up not on our property to do things not on our property.
Okay.
I know I'm down to about a minute, so like to just ask if the court has any other questions. Thank you for your time. I appreciate it.
Thank you very much. All right, for the appellant.
Your Honor, if you take a look at that statute that the justice was referring to, invitation means that the visitor entering the premises has an objectively reasonable belief that he or she has been invited or is otherwise welcome on that portion of the real property where injury occurs. That begs a jury question. How do we reach summary judgment on invitation, whether or not an invitation occurs, where it says has an objectively reasonable belief? So who determines whether or not Mr. Akins had an objectively reasonable belief based on these facts, based on the facts that are in the summary judgment motion itself?
Do you agree there's an implied consent issue that would only elevate him to an uninvited licensee?
Well, no, this is invitation. So we're talking an invitee. Does this person have an objectively reasonable belief?
No, counsel,
that
that's
he or she has
invitation.
been invited?
No. That's the definition for invitation under 768.075.
Correct.
Which deals with discovered trespassers and undiscovered trespassers.
Correct. And which is what the appellees are arguing that Mr. Akins was, which was an undiscovered trespasser.
Let me ask you this briefly. If we agree that there was an issue as a trespasser, but also agree that only elevated him to an uninvited licensee, is there a duty to warn of criminal activity? That, for example, there's a third DCA case saying that with regard to uninvited licensee, we have said that the danger of crime and criminal assaults is an open and obvious danger for which there is no duty to warn. So just on the uninvited licensee issue only, because that's what was moved forward for summary judgment. It was either a trespasser or uninvited licensee. Would there be a duty to warn as to an uninvited licensee?
Not according to the case law, no, Your Honor.
How would you deal with Lane, the case that Judge Sasso just referenced, which is Lane versus Estate of Morton, third DCA?
I'm sorry, I didn't hear the first part of your question.
How would you, that's the case that Judge Sasso just referenced is Lane versus Estate of Morton. How do you deal with that case?
We can't. I mean, that's the case law. I mean, we can't deal with that. Our position is that he's not an uninvited licensee. I'd like to
prevail. You basically, in order to prevail here, you concede that you have to establish that he was an invitee.
Correct.
Not an uninvited. Uninvited licensee is not enough.
No, for purposes of this, no. We would have to demonstrate that he was an invitee.
All right,
Either
leaving out the affidavit of what is your best argument that he was an invitee? What are your best facts that were before the trial judge that would support such a finding?
That he was there all the time, that everyone knew him, that he had a nickname as the CD man. He was there so frequently. And we're not talking about over a period of weeks. We're talking about years. And then I don't want to leave out the affidavit because
But doesn't the fact that he was selling instead of there to be a customer, what does that do to your argument that he's an invitee?
It wouldn't be any different than the store clerk. The store clerk is there working. If criminal activity resulted in the store clerk's death, the store clerk would not only have a workers' comp claim against his employer, potentially, but would have a premises liability claim against the owner of the shopping mall.
But the employee's working for the benefit of the property owner. Would you agree?
Well, remember, the Supreme Court eliminated the benefit analysis. It is whether or not there's an invitation.
In that affidavit, can you point anywhere in the affidavit where it reflects that it was based on the affiant's personal knowledge?
No, Your Honor. She does not say in the affidavit that it's based on personal knowledge. But again, the case law indicates that if the affidavit suggests or has sufficient facts where the court can determine that it's based on personal knowledge, it should be considered.
But which facts in the affidavit can we look at to make that conclusion? I mean, when I read the affidavit, I had no idea where she got her information. It could have been third hand from some individual that is not even, doesn't even appear in our record, or it could have been any other person, including a representative of Patador. So how did she get the information, and show us where in the affidavit she tells us that?
Well, when it comes to this information, if there's an inference to be drawn, the inference is supposed to be drawn in favor of the non-moving party. So if you're looking at it and saying, well, it could have come from her or it could have come from someone else, because the appellant wasn't the moving party on summary judgment, the court has to infer that it came from her, because all inferences have to be drawn in favor of the non-moving party.
Even the admissibility of the evidence?
Well, again, remember the Fifth District Court of Appeal in Petruska, and I think we cite that in our motion, talks about the admissibility and whether or not it has to be in the exact form that would be admissible at trial at a summary judgment hearing.
All right. All right, your time is up. Mr. King, any other questions from the panel? Okay, well, thank you both then, and we'll be in recess.
Thank you.